Swayam Prabha. Digital India. Educated India.
Hello all, let's start the module and in this module we are going to discuss about the intellectual property based conduct under this article 102. So, under this module we will be discussing regarding the principle for assessment under this article 102 of the Treaty of Functioning of European Union, and in particular we will look into how the intellectual property related licensing or other agreements has been evaluated under this article 102. So, as we discussed in the earlier classes, the article 102 of Treaty of Functioning of European Union basically prohibits abuse of dominant position. So, in particular the article states that any abuse by one or more undertaking of a dominant position within the internal market or in a substantial part of this market shall be prohibited if it affects the trade between the member state. And these kind of abuse may be created in particular by four ways. First, if the agreement or the contract directly or indirectly imposes unfair purchasing or selling prices and also imposes other unfair trading conditions to the third parties or the parties involved in the agreement. And second, if it limits the production, market or technical development which is prejudiced to the consumers. Third, if it applies dissimilar conditions to equivalent transactions to the other trading parties which may place them in a competitive disadvantageous position. And fourth one, if the contract have certain supplementary obligation by which the supplementary obligations which is not directly related to the subject of such contracts and it is required for the acceptance by the other third parties, then also it may act as an abuse of dominant position. So, if we look into critically article 102, so there are two critical things. First, it is not about the abuse of dominant position by a single undertaking. One or more undertaking may come together and they may have both the undertakings may have dominant position in the market, and so it is not about this it is not applicable only to one undertaking. Two or more undertaking can be liable for the abuse of dominant position as well. And second, the dominant position per se is not prohibited under this article 102. It is the abuse of dominant position, and the European Commission judges the abuse of dominant position based on its evaluation of appreciable adverse effect on the competition in the market. Means they looked into the competition, the fair and healthy competition which is the objective of this European competition policy. So, if they look into whether the practices are creating a divide between the internal market, or is it whether the practices is having certain adverse effect on the total competition in the market, maybe in terms of product generation, product supply or the related things. And if we critically look into the statements or the regulation of article 102, so as we discussed, so there are two things. First, a dominant position, and second is the abuse of dominant position. So, in order to decide any case related to abuse of dominant position, the Commission has to establish first that the entity or the undertaking is having a dominant position in the European market or in the member state. So, there are it has been decided through many case laws, means the case laws has given a test for test or conditions about if the undertaking satisfies those conditions, it may be regarded as a dominant undertaking. And also there are certain guidelines which has been developed in due course which states how a company or a firm or an undertaking can be considered as a dominant undertaking. So, one of the earlier or critical case law was started with this Hoffman-La Roche decision of European Court of Justice. So, there the court held that the dominant position relates to a position of economic strength enjoyed by an undertaking which enables it to prevent effective competition being maintained in the relevant market by affording the power to behave in an appreciable extent independently of its competitor. Means, if an undertaking is having a strong position in the economic market and if it can behave independently of its competitor, means if it can define or it can dictate how the company or the market should behave in the market, then yes, it may be regarded as a dominant position. So, the independent behavior of a firm or an undertaking in the market is very critical for determining whether a company is holding a dominant position or not. So, again in assessing the dominant position, there are 2 or 3 more criteria which may be looked into. First, this dominant position is always looked into a relevant market. So, if we are talking about the total European internal market, and so the relevant market comprises maybe a market in a member state or wherever the product is being sold or manufactured, and again it looks into like the elasticity of the offer or the demand, the substitutability aspect which we will discuss in the later segments. And again the geographical scope, means the geographical boundary as well as the product nature and quality and the substitutability of the product is very important in deciding the relevant market. So, one of these first landmark cases or critical case which decided the relevant market was this United Brands case. The judgment was given in 1978, which gave a clear idea about what can be considered as a relevant market, which this case we will discuss after some time. Apart from this case law, in 1997 the commission gave a notice regarding this market definition as well, where the commission emphasized on the demand side substitutability. So, there the commission has defined that for the purpose of this market definition, demand substitutability is of greatest significance than the supply substitutability and the potential competition. Means like there is 2 part, a demand and the supply. Means so supply, the manufacturers are basically on the supply part and the consumer is at the end of receiving the demand. So, it is basically the consumer's decision or the consumer's viewpoint which has to be taken into account while deciding whether the product can be substituted or not. In particular, in the paragraph 14 of this notice, so the demand substitutability is measured by the range of products which can be taken as an option for substitute by the consumers. Means they have clearly specified that the consumer's opinion regarding the substitution of this product is very critical while deciding the market. And in this regard, the European Commission has adopted a test which is known as SSNIP, which stands for small but significant non-transitory increase in price test. Basically, this is an American test which has been imported from United States, and it is a hypothetical monopolist test that ascertains that the level of demand and demand substitution, which are the instances when the consumer will transfer their allegiance to another product as a result of this price increase. So, basically it is designed to analyze whether the increase in the price would be profitable, or if there is increase in the price, so customer would prefer substituting the product rather than buying that product. For example, if there is a product which is available at 50 rupees per unit and there is 2 and similar product which are available at 30 or 20 rupees per se. So, if the price of this product is increased by suppose 5 or 10%, then whether the consumer will prefer to buy that product or the consumer will shift its allegiance to the product B or C. So, basically this SSNIP test determines that whether this product the consistency of the product in the market after price increase can be retained or not, and it is very essential in determining the relevant market of the while deciding this abuse of dominance cases. And secondly, so we talked about first the deciding about the dominant position, and in that the scope of this relevant market as well as the geographical market is very essential. And also one of this critical thing was the share of market hold by this company. Like now the European Commission has developed certain guidelines which says that if a market, if an undertaking is holding a share of 40% or less, it is not coming under the purview of section article 102. So, it also depends how much share a company holds in the market before judging these kind of cases. So, now coming to the second aspect of this article 102, that is the most critical aspect, the abuse of dominant position. So, as I said, dominant position per se is not prohibited, it is the abuse of dominant position. So, finding whether an undertaking has a dominant position itself, so finding that an undertaking has a dominant position is not a recrimination, but simply means that irrespective of the reasons for which it has such a dominant position, the undertaking has a special responsibility not to allow conduct to impair genuine undistorted competition. Means if a company or an undertaking is having a dominant position, it has certain duty. So, it should not hamper the healthy competition in the market, the common market in the European Union. So, this thing has been led in the decision of this Michelin cases in 1983. So, this is one of these one of the landmark decisions which gave a idea regarding this abuse of the dominant position. And then as I mentioned earlier also, so United Brands versus Commission is one of this landmark decision which gave a definition regarding the relevant market as well as the laid down the test for the dominance. So, coming to the brief facts of these cases, this United Brands company was a main supplier of bananas in the European Union. So, the Commission found that the United Brands company or the UBC is holding a dominant position in the market, and it has abused the market because the UBC has prohibited the distributors from reselling of these bananas that were still green, and it also prohibited or it did not give a license to another distributor named Olesen, because Olesen sometimes advertised for a competitor company, and for that reason UBC did not give license to Olesen. So, Olesen filed a complaint for UBC in the European Commission, and the Commission has viewed that the UBC hold a dominant position and it has violated or abused its position. However, aggrieved by this decision, UBC has appealed to the Court of Justice, and UBC has said that the European Commission has erred while taking the relevant market, because UBC is only supplying the bananas in the European market. So, for as the point of view of UBC, it's only the bananas should not be taken alone as a relevant market, it should be the whole fresh fruit market which should be taken into consideration before deciding whether the UBC is holding a dominant position or not. So, basically the issue was whether UBC holds a dominant position in the relevant market or not. So, there the court held that the dominant position in the market relates to position of the economic strength. So, here it was all regarding this banana. So, there again the court looked into the aspect of substitutability of the product. So, the courts looked into the aspect that the interchangeability parameter has been met or not. So, in this case the court held that whether the banana could be singled out by such special features distinguished from other fruits or not is will be judged by the consumer point of view. Means if suppose there will be no raw fresh banana in the market, will the consumer who has a preference for this banana will buy another fruit for another fresh any other type of fresh fruit to mitigate their demand, or they will only rely on the fresh banana. So, by this they found that the consumers will only rely on the banana. So, the banana market is only relevant for this banana itself, and it is not about the whole fresh fruit market. So, the European Court of Justice also held that like the UBC held a dominant position and it has abused its dominant position by not giving the license to its competitor or its distributor. So, this is one of these landmark cases where the definition of the relevant market has been judged by the interchangeability parameter, the geographical extent the market is spreading, and also one of this important factor is like the factor how long this market has been operating in the market. So, the time also plays a critical role in deciding all these things. So, here in this court particularly I will just repeat, the court considered many factors including the seasonal substitutability in general between the banana and all the seasonal fruits, and it concluded that a very large number of consumers having a constant need for bananas are not noticeably, even appreciably enticed away from the consumption of the product by the arrival of the other fresh fruit. So, banana market is a market which is sufficiently distinct from the other fresh fruit market. So, here the relevant market is decided only relevant to banana, not including other fresh fruits. But it is all not the case that always the European Court of Justice agrees to the decision given by the Commission. In one of these cases, this continental cane case, the court disagreed with the opinion of the Commission on the relevant product market. Here the case was about light metal cane which is used for packaging of fish and the meat. So, there the court held that in order to be regarded as a constituting distinct market, the products in question must be individualized, not only by the mere fact that they are used for packaging of certain product, but by particular characteristics of the production which makes them specifically suitable for this purpose. So, here in this case particularly the court held that a dominant position on the market for light metal containers for meat and fish cannot be decisive, as long as it has not been proved that competitors from other sector from the market cannot enter into the market by simple adaptation. So, if we look into the various case history, basically again it also depends the nature of the very product. The earlier case it was regarding the raw banana, where it is just a supply of the kind of fruit, but here it is a kind of production thing where a particular metal has been taken into consideration to create a container. So, again, so not only the process the nature of this product as well as the process of the product, how it is affecting, whether it can be adapted by other person or not, that is also very critical in deciding a relevant market. So, we discussed about the two parameters, one is the relevant market, second is the dominant position. So, there are also specific guidance has been given on this article 102 regarding this enforcement. And in the para 2 of this guideline on the assessment of article 102, there are 3-step test has been laid out. So, it basically to determine the dominant position in the relevant market, 3 tests or 3 parameters must be examined. First, constraint imposed by the existing suppliers from and position on the market or the actual competitor, that means the market position of the dominant and its competitor. Second, constraint imposed by the credible threat of future expansion by actual competitors or by entry by the potential competitors, means whether it is hampering the competition or promoting the competition. Third, constraint imposed by the bargaining strength of the undertaking's customer, means how it is affecting the buyer's power, purchasing power of the buyers. So, these three parameters must be taken into consideration before enforcing this article 102 in any of this conduct. Now, coming to the next critical part, that is the abuse of this dominant position. So, all these case laws or all these directives which all these guidelines which has been given. So, it basically to sum up, there are basically 3 kinds of abuse. One is exploitative abuse, second one is exclusionary abuse, and third one is the discriminatory abuse. So, mainly we can classify into 3 kinds of abuse. So, the exploitative abuses are particularly practices those exploits the customers directly, and it is directly harmful to the consumers. For example, the article the subsection A of article 102 directly says that directly or indirectly imposing unfair selling prices or unfair condition. Means if there is only one manufacturer for a product, and because he is not sharing his technology or intellectual property, and he is selling the thing in a higher price, so which is directly affecting the consumer, then it would be a kind of exploitative abuse. Second is a exclusionary or the anti-competitive abuse. So, basically this includes all those practices that excludes the competitors from the relevant market and restricts the competition. And it may be beneficial for the consumer in the short term, but it may have long detrimental effect due to the reduced competition. For example, this tying, refusal to supply, exclusive dealing agreements, predatory pricing, price discrimination, all these are the form of exclusionary or anti-competitive abuses. Third is the discriminatory abuse, which is the practices that discriminates between the various customer. And as per this article 102 subsection C, means applying dissimilar conditions to equivalent transactions with other trading parties and placing them in a competitive disadvantageous mode. So, in maybe in different geographical location, you are selling the thing in different prices, and critically binding the third parties or the other contracting parties in some undue agreements, which is not directly related to the object of the agreement. So, this kind of thing will come in again the discriminatory abuse. So, now we will go one by one to all these kinds of abusive practices. So, first in one of this like this Hoffman-La Roche case, a broad definition regarding this exclusionary abuse has been given, and so basically it states that the concept of abuse in an objective is an objective concept relating to the behavior of an undertaking in a dominant position, which is such as to influence the structure of the market, and as a result of this very presence of this undertaking in question, the degree of competition is weakened, and through the recourse or to methods different from those with the condition of normal competition or competition in the product or the services on the basis of the transaction of the commercial operators, has the effect of hindering the maintenance of the degree of competition. So, basically three things: it influences the structure of the market, the degree of competition is weakened, and it hinders the maintaining the degree of competition, and it hampers the growth of the market along with this practice. So, this Hoffman-La Roche cases, because it was one of these cases where the Hoffman-La Roche was one of the leading vitamin manufacturers. So, it manufactured nearly out of this total vitamin segment 90% like 90% of the manufacturing was from Hoffman-La Roche, and it was one major distributor for one of the other vitamins which are used for the normal medicinal industrial purposes. And since it was the major manufacturer, it gave particular kind of discount and some particular lucrative offers to the other distributors to buy the vitamins from them only. So, like in the whole European internal market, it tried to have a dominant position, and by virtue of this action, it was said that it abused the dominant position from the year around nearly 4 years. And for that, the European Commission has fined them very heavily, nearly more than $1 million was imposed as a fine. So, there for the first time, the definition for the concept of exclusionary abuse was introduced. Coming to critically to the intellectual property rights in the agreements, as we till now know that intellectual property rights are a kind of monopolistic right. So, exclusionary right. So, it gives the privilege to the inventor or the proprietor to use this right for himself, and he may use it. So, by virtue of this existence of the right, it is said that it can exclude the other competitors from using the right. So, it is a kind of hindering competition at the first place. But again, it is also necessary for exercising the rights of the IPR. if a company has developed a new technology which is giving a product of better quality or maybe of lower prices, then obviously he must get some benefit from his technology. And it is not per se hindering the other competitors to further innovate or to come up with the other technologies that may be a better that may be advantageous position or a better position from the earlier inventor. So, so in this regard, IPR per se does not give any company to be a dominant company, because IPR per se, IPR is not restricting competition, but again existence of the IPR and exercise of the IPR, these are two things. So, there is existence of the IPR, one company is having certain intellectual property rights, maybe in the form of patent or any other form, he may use it for its own purpose, but again it should not hamper the other competition in the market. So, one of this one of this decision regarding the existence and the exercise of the IPR was the Volvo versus Wang case in 1988. There basically it was all about protected design, right. The Volvo, the manufacturer of this Volvo cars, they have certain design registered for the front hood of this car. So, which is specific to the car segment, and Wang, another manufacturer of this replacement part, without they infringed their designs right by without taking their licensing, they started selling the front hood to the consumers. So, Volvo initially filed a case of infringement and saying that this is violation of their right IPR intellectual property rights, but however, Wang said that because Volvo refused to give them license, so Volvo is abusing the abusing its dominant position. However, the court held that the IP right of the proprietor grants exclusivity, and that is an obligation, and that an obligation to license even in return of the royalty would lead to the proprietor thereof being deprived of the substance of his exclusive right. Means whether to license or not to license, it solely depends on the proprietor itself. It does not necessarily the proprietor does not necessarily have to give the license to any other third party. So, in this case, a refusal to the grant of such license cannot itself constitute an abuse of dominant position. So, this is one of this critical case, because this was related to a car segment. So, what happened in that car segment? So, there is two things, one is a manufacturer of the car, means total whole car, and other is the manufacturer of the replacement part. But when a consumer is buying a car, like he looks into where can I get the services, where can, if the car is damaged or something. So, it is a in this case the relevant market has two segments, one had this total car segment and other is a replacement part. But again this is two different things, but again having some interlinkage. So, in this court in this case the court decided that the Volvo has the right not to give the license to Wang, because consumers are well aware that they are purchasing a car from a particular manufacturer. So, if anything happens to the car, so they may get the replacement from the manufacturer itself. So, they do not depend they do not necessarily have to depend on the third party. If they want, they can, but it is not necessary on their part. So, here in this case the existence versus the exercise of the intellectual property right was dealt very beautifully, but some critically argue that it is a very narrow decision, but however, this is one of these landmark cases which laid this concept of existence and IPR. So, so again there are few critical things associated with this abuse of dominant position. Means per se IPR is not hampering the competition, but again there are, if there is a holder of intellectual property right, under certain exceptional circumstances it may be considered that the holder of the intellectual property right is abusing the dominant position. So, this is known as the exceptional circumstances test. So, in this series we will discuss 2 or 3 more cases. So, we will continue with that.